Yeah, thank you, my lord. I will not take a lot of time. Just address the issue of conservatory orders. Yes, my lord. Thank you, my lord.
I've added it from 25 to 30.
That's all, my lord. I'll take that time. My lord, I will begin first of all by submitting on the practical implications of the orders of the proceedings before your brother, Justice Mugambi, in petition 522 of 2024, vis-a-vis these proceedings. My lord, and I want to make the firm submission that, my lord, the petitioner in this matter, who is the petitioner in 522 of 2024, is precluded by the doctrine of estoppel of record. From raising issues, and my learned colleague Mr. Paul Nyamundi has raised these issues, raised this point, issues that he has raised in petition 522 in this instant petition. My lord, let me just be very clear that in 522 of 2024, my learned colleague Mr. Ongoya, as led by Senior Counsel Paul Mwite and assisted by Faith Waigu and Mr. Mashare, who are in these proceedings, firmly told the court and submitted in this very bench that they were not pursuing the prayer for conservatory orders. At that very moment when they were making those submissions, the proceedings in the National Assembly with respect to impeachment, phase 1, had been concluded. So, my lord, they only pursued one question. That is the question of certification. My lord, actually, if you look at the proceedings, they raised an objection. My lord, they raised an objection, my lord, to our submissions opposing conservatory orders, stating that it was not one of the matters which they wanted canvassed. So, my lord, the implication of these submissions,
do I understand you to say that they didn't want you to respond to the application for conservatory orders?
yes, my lord, in petition 522 of 2024, because according to them, they didn't want to argue that petition, that aspect of the prayers. All they wanted was for certification. So, my lord, if you now look at the ruling of Justice Mugambi, he only addressed the issue of certification. So that, my lord, in terms of the implication, our submission is that if there is any value to be derived from this application, the value is for them to ask that this application be consolidated with petition 522 of 2024. My lord, that will be consistent with the Mutunga rules, especially Rule 2. And, my lord, public policy in the judicial decision making. My lord, public policy in judicial decision making. My lord, which requires consistency, that litigants need to lay a platform for consistency in judicial decision making, so that there is no conflict from decisions which are rendered by our honorable judges. So, my lord, that public policy will be given effect. by the order for consolidation. Which, my lord, you have jurisdiction, inherent jurisdiction to make, even when they have not asked for that order today. You have inherent jurisdiction to make. My lord, I'll briefly mention the test on the ground of conservatory orders. My lord, they have submitted, the petitioner submitted that he wants conservatory orders to stop proceedings in the Senate. My lord, my submission is that if you examine the nature of proceedings for impeachment, my lord, Article 145, these proceedings have not completed. My lord, proceedings in the National Assembly and proceedings in the Senate are one continuum. My lord, both the National Assembly and the Senate. So, my lord, there is no decision yet by this arm of government with respect to impeachment to, of necessity, require this court to issue conservatory orders at this stage of these proceedings. So, my lord, if you look at the test for the grant of conservatory orders, which my colleague, senior counsel Paul Mwite cited, in the case of Peter Gaterau Munya, my lord, my colleague didn't cite the last part of the test. My lord, which requires you to consider, my lord, and make a delicate decision. Apply the doctrine of restraint and make a delicate juridical decision to allow these proceedings to go on. Why, my lord? Because of a foremost constitutional value known as the constitutional doctrine known as the doctrine of separation of powers. My lord, these proceedings which are before the Senate are legitimate constitutional proceedings. My lord, public participation has been conducted. They can question the adequacy of that public participation, but my lord, public participation has been conducted to a sufficient degree of acceptability. My lord, that is why in the response, my lord, you can see numbers being quoted by the petitioner. So, my lord, if I submit that if there was no public participation in these proceedings, in the impeachment proceedings, my lord, then that will have made a lot of sense to injunct the proceedings at any time when the petitioner comes to court, because, my lord, public participation is a core constitutional value. So, my lord, because public participation has been conducted, the delicate exercise of judicial function, the petitioner comes to court, because, my lord, public participation is a core constitutional value. So, my lord, because public participation has been conducted, the delicate exercise of judicial function, my lord, then requires that you hold on a little bit. You don't issue precipitate conservatory orders to stop this legitimate constitutional process of impeachment. My lord, the implication on the opposite side is that, my lord, these proceedings are not about criminality, impeachment proceedings. My lord, they are about political responsibility. And, my lord, in the design of the 2010 Constitution, my lord, they exist in the constitutional and legal order for good reasons, my lord. My lord, they exist so that the legislative arm of government is able to hold certain state officers, my lord, into account. So, my lord, they are not illusory or unknown proceedings to law. They are proceedings which are recognized by Article 150, Article 145, and Article 146 of the Constitution. My lord, secondly, these proceedings are time-bound. My lord, in the case of Justice Kariuki Mate, and my lord, the case of Justice Kariuki Mate, my lord, is a typical case, my lord, for you to apply in this matter, because, my lord, the facts appear to be tailored for this kind of situation. My lord, petition 32 of 2014, Justice Kariuki Mate versus Martin Nyaga Wambora. A similar matter, my lord, where you, my lord, petition number 32 of 2014. My lord, and I would like to briefly, my lord, reflect on what the Supreme Court has said in paragraph 83 of this decision. Paragraph 83 of the decision. 83, my lord. So, my lord, the Supreme Court is asking itself a question. That, my lord, should ex parte orders be issued? And in this case, my lord, we are reformulating by interpreting, because the implication is the same. Be issued, my lord, with respect to proceedings which are active before the legislative arm of government. And, my lord, you can see here, the Supreme Court is restating the doctrine of separation of powers as one of the principles which shall guide you in that paragraph 83. Because, my lord, the implication of the conservatory orders is that then the proceedings, these time-bound proceedings, my lord, these time-bound proceedings before the legislative arm of government will then be stopped. And, my lord, I submit that it is not unique for the Constitution to require this kind of proceedings to be time-bound. And, my lord, in paragraph 84, to require that you exercise what the Supreme Court judges are called inner restraint. Inner restraint. Because, and, my lord, the Supreme Court is saying exercise this inner restraint in the context of express mandate allocated under the Constitution to Parliament. And, my lord, the idea is to circumvent and avoid conflict and crisis. Conflict and crisis in the discharge of constitutional responsibility. So, my lord, we are urging that you give deference, that, my lord, you allow at this point in time these proceedings to go on before the legislative body and to exercise judicial restraint and not to issue conservatory orders. My lord, exercising judicial restraint, and as I submitted, is in line with the test for the grant of conservatory orders in Peter Gatirao Munya. My lord, again, on the second limb on that question, my lord, they have imputed, the petitioners have said that standing orders number 64, my lord, does not provide for adequate time to do public participation. My lord, they made that submission. And, my lord, I would like you to look at the same decision of Kariuki Mate, paragraph 93. Because, my Lord, Standing Order number 64 is made pursuant to the provisions of the Constitution. My Lord, Standing Order number 64 is made pursuant to the provisions of the Constitution. And here, my Lord, the Supreme Court is saying that this standing the orderly conduct of the business, the operations within the legislative arm of government. So, my Lord, I want to submit that these standing orders then enjoy the presumption of constitutionality. So that, my Lord, the standing orders provide that if a motion is introduced before the House, the National Assembly, for the impeachment of President and Deputy President, my Lord, the standing orders require that that motion be dispensed of, my Lord, within 7 days. My Lord, within 7 days. And, my Lord, that takes us again back to the doctrine of time-bound proceedings. My Lord, within 7 days. My Lord, what that means...
So, which law says 7 days?
My Lord, standing orders, my Lord. So that, my Lord, now going to the Constitution, my Lord, Article 145, on the removal of president, which Article 150 equates, that shall also apply for the removal of deputy president. My Lord, Article 145, paragraph 3, also says within 7 days of receiving the resolution from the Speaker of the National Assembly. My Lord, within 7 days from receiving this resolution from the National Assembly, my Lord, the Speaker of the Senate is supposed to commence action, proceedings towards the completion of the removal of, or otherwise, of the Deputy President. My Lord, to consider the motion, my Lord, to commence the proceedings to consider that motion for the removal of President stroke Deputy President. My Lord, thereafter, they only have 10 other days, my Lord, 10 other days to finish the process, to make a decision. My Lord, you can correlate this to Article 140 of the Constitution of Kenya, which requires that a petition once presented to the Supreme Court for the validity of a presidential election must be determined within 14 days. So, my Lord, it's not unique for these proceedings to be determined in this manner. My Lord, there are constitutional policy reasons why that is the case. My Lord, perhaps because this position is important and stability of the nation is very critical, you don't want to keep people in abeyance on who is their president and deputy president. My Lord, the deputy president, when there's a vacancy in the office of president, they're supposed to assume office as president. So, my Lord, because of these constitutional timelines, then one of the reasons one, my Lord, can make is that because of the stability of the nation, you cannot have a vacancy in the office of president and deputy president within this kind of periods. That is why the Constitution, my Lord, has set strict timelines concerning their removal from office or election into office. So that, my Lord, this is now tied on the public participation. So that, my Lord, what happens on the public participation, my Lord, is that whereas public participation is not provided for in Article 64 of the Standing Orders, my Lord, public participation is a constitutional imperative which so many authorities have laid down, and including this court, my Lord. So, my Lord, this constitutional imperative known as public participation must be done within the confines of the timelines which have been laid down. So, my Lord, the National Assembly was required to do public participation, my Lord, within those timelines and not create excuses. And my Lord, that's what the National Assembly did. Public participation within the constitutional timelines. My Lord, submissions was made by Senior Counsel Paul Mwite on whether a response by the deputy president is needed when you are going to public participation. My Lord, in my view, that is stretching the issue too far. My Lord, what is before the House of the National Assembly is often a motion. And my Lord, the Constitution talks about a motion for the removal of deputy president. My Lord, that motion, before it is determined, public participation must be conducted. So my Lord, the obligation of Parliament is to ensure that that motion goes to the people, for them to air their views on what they think the motion, on what they think the elected members should do with the motion. And my Lord, sovereignty, they exercise it directly or indirectly through their elected representatives. So, my Lord, there is no obligation whatsoever to send a response to the people, because by that time, there are no proceedings contemplated in the standing orders for pre-impeachment public participation, because there is no motion. It will be speculative to go to the people with a motion which has not been introduced to the House for adjudication. Just like this court cannot adjudicate, my Lord, on a petition which is not before it. People will be talking to the media about the petition, but the High Court will only be seized of that petition when it is brought before it. My Lord, that is very important to distinguish. And my Lord, the efficacy of or adequacy of this public participation see that at this stage of the proceedings. My Lord, the petitioner is inviting you to make conclusive determination on the question of public participation. My Lord, the response from the National Assembly that public participation was indeed done, and the mere fact that it was done, then, my Lord, you cannot consider that on merits at this stage. So, my Lord, we urge that you don't grant the conservative orders. So, my Lord, the application of the conservatory orders will to destabilize the process which is before the Senate. My Lord, there is no timeline, there is no guideline on what happens when the court has issued conservatory orders. What happens to the timelines in Article 145? What happens to those timelines when conservatory orders are issued? My Lord, the doctrine of proportionality in the Mutunga rules require that you exercise some restraint as not to issue conservatory orders at this stage. My Lord, Senior Counsel Paul Muite talked about gross violation of the Constitution as one of the grounds. He says the motion does not meet the motion for impeachment. But, my Lord, again, in the Sonko case, the Supreme Court has said the role of the court is not to look at the merits of these allegations. My Lord, instead, the High Court is supposed to just look at the process issues. Has the National Assembly complied with the standing orders and the provisions of Article 145? My Lord, if the answer is yes, then, my Lord, you allow those proceedings to continue and conclude. But now that my colleague, Senior Counsel, talked about gross violation of the Constitution, my Lord, allow me to say that indeed, from the motion, the Deputy President, there are serious allegations that the Deputy President is facing. And, my Lord, as I wind up, my Lord, the Deputy President is participating in the proceedings before the Senate. My Lord, that is important. He is participating in the proceedings before the Senate as well. So, my Lord, he cannot approbate and reprobate. He cannot participate in the proceedings before the Senate. My Lord, yes, my Lord, the process is going on. My Lord, allow me to quote a document, my Lord, which, because my Lord, I'm not speaking from the bar. Yes, my Lord. Yes, my Lord. From a response which was filed, which we have filed, and which also my colleague have filed, my Lord, an affidavit, supplementary affidavit by regarding Gachagua. My Lord, this is what they have annexed. My Lord, they have annexed a letter from the Senate inviting them to submit a response by 5 p.m. today, stating that the motion is before the House. They were given material which constitute this motion, and they were required to file a response. My Lord, under Article 145 of the Constitution, those proceedings have already commenced. My Lord, what I'm saying is the 10 days for the Senate to consider that question have already commenced. The proceedings are active before the Senate.
I hear that, but as to whether it's actively engaged, what you refer to a document that you have been invited.
Yes.
Not the document that has filed.
That's correct, my Lord.
So can we restrain ourselves to that point?
Okay, my Lord. I will rephrase then, my Lord, by saying that the Senate has invited the Deputy President,
That's fine.
yes, to appear, my Lord, before it to answer on these weighty allegations which the petitioner says concern gross violation of the Constitution. My Lord, now that brings out a fundamental point. My Lord, he has opportunity in accordance with the provisions of Article 50 of the Constitution. My Lord, he has opportunity to air his grievance in a trial process at the Senate. My Lord, that's a fundamental tenet of the doctrine of natural justice. He has been given an opportunity to come and ventilate his concerns about public participation, content of their motion, the allegations he is facing. He has opportunity to ventilate those concerns in a quasi-judicial process, my Lord. My Lord, quasi-judicial process. So, my Lord, it's better that we allow him to exercise his opportunity to appear before this quasi-judicial process for the trial of these allegations. My Lord, the issuance of conservatory orders will deny the parties that opportunity to subject the allegations against him in a constitutionally tested and compliant process of impeachment. My Lord, the senators act as jurors, as in this case, stroke judges. My Lord, they are required to make up to decide on each and every allegation that he is facing. So, my Lord, the doctrine of ripeness then applies against the Deputy President at this stage of the proceedings. My Lord, his complaint is not ripe for judicial adjudication yet. My Lord, as I wind up, the roof is not on fire. My Lord, the courts of the doors of this court have not closed at him to come and ventilate his concerns about the entire process completed. But after the impeachment proceedings have concluded. And my Lord, this is the tenor and the effect of their submission in petition 522 of 2024. Whereas conservatory orders were sought, they abandoned the quest for conservatory orders in 522 of 2024. My Lord, the questions concerning public participation have been certified as raising substantial questions of law in 520 of 2024. My Lord, there's a prayer on arresting, suspending, or interfering with the decision of arresting, suspending, or interfering with the decision of the Senate in 522-2024. And my lord, those proceedings anytime now will be before a 3-judge bench for adjudication. My lord, to the extent that that prayer is live in procedure actively pending for another bench, then in these proceedings, they will be doing what we call lemon selling. If they seek conservatory orders, these proceedings, they'll be doing what we call lemon selling. My lord, I rest a case and pray that you don't consider granting the orders for conservatory orders at this stage. Indeed, my lord, if there's any decision with respect to consolidation, my lord, we concede that this petition can be consolidated with petition 522, my lord, for good order, my lord, so that there is no conflict in terms of decisions which are made by the High Court on the same subject matter, my lord. My lord, with respect to the same petitioner, my lord, the same petitioner. Thank you, my lord.
Yes, my lord. Yes, I have my time.
I need to ask a question to Mr. Oga.
Yes, my lord.
You refer to paragraph 93.
Yes, of the...
Although I understand what is being said.
Yes.